Hello everyone. I hope you are aware that last week SEBI has issued a consultation paper on the review of the disclosure requirement for material event under LODR. So just to brief the provision, I made this PPT. So let's start this presentation. So as a proposal, SEBI has proposed to introduce a quantitative criteria to determine the material event. As of now, it is left to the wisdom of the board of directors to determine the materiality criteria, and what the most of the listed companies are doing. They just copy paste simply the LODR provision into their policy, and it will not help anybody, either regulator or the company itself, to identify those events which require to be disclosed on the basis of materiality. That's why they now introduce these three criteria, which is: first is a turnover, second it is net worth, and third is average profit after tax on the basis of the last 3 years audited standalone financial statement. I believe this third criteria would create a problem, especially for loss-making companies, because in case of loss, you don't have a profit after tax figure, and probably I don't know, what figures you will take as a pet. It could be zero as well, and if it is becomes zero, if there is no profit, I can consider the figure as a zero. Then they are saying you have to judge on the basis of lower of the following event, and lower figure would be zero, and it is all the event will fall under the disclosure requirement. I don't think this would be the intention. So probably this would require some minor tweaking, especially in the third point. Then the next proposal is the timeline. As you are aware that regulation 30 sub-regulation 6 specified certain timelines which are adhered to by the listed entity while disclosing event. Currently the general timeline is a 24 hours except board meeting items. Now they categorize those timeline into the four category. One is a 24 hours event, then the second is a 12-hour events, and the 30 minutes event which are coming out from the decision of the board of director. And as usual, in case there is a delay in this not fulfilling those timeline, then you have to explain the delay of such. And the next change is, as of now, if there is a news or any report in the print media about a listed entity, so now existing provision like listed entity has a discretion to uh, confirm or deny that news. Basically, it's not mandatory for the company to comment on such news. But now onward, if these proposals coming into law, so top 250 listed entity, have to confirm those events if any news uh, is being floated in the print media or in any form of media. So now it will be mandatory for top 250 companies. Then the next proposal is insertion of new regulation. So if a listed entity receive any communication from regulatory or statutory or enforcement or judicial authority, then there would be a disclosure requirement in the specified format, which subsequently prescribed by the SEBI. Then the new proposal is, if the listed entity acquiring a share of a newly incorporated, so basically it's not in acquiring the share, it's more about subscribing the shares of a newly incorporated company. But as of now, few companies are not disclosing such acquisition, because the word used in the existing regulation is acquisition, and when you are incorporating a company, there is no company into existence. So it is just to avoid the confusion, they have also added that word, the newly incorporated. So now if listed entity are incorporating wholly owned subsidiary or subscribing share to the subsidiary or any company, and they are meeting the or they specifically written also the cost of such acquisition of shares, exceed the criteria which are supposed to be, added if the proposal will be accepted, which I just discussed, which is like your turnover, net worth, and pat. If it exceeds that, then there will be a disclosure. So this new proposal is more about to avoid the confusion in case of the newly incorporated company. Then the next proposal is, if there is a fraud and or default by the certain company, certain person of a listed entity, then there is a disclosure. Now, into the category or the list of those person, they have also added director and the senior management and the word subsidiary as well. So there will be more chances of disclosure, because it could be possible, the fraud or the default uh, director or the senior management. Then there is a next proposal. Uh, so while the existing provision are such, if there is a change in the director or KMP, definition of the KMP, they have also prescribed managing director, CEO, CFO. Now they have added or proposed addition of a senior management. So these, this change is more about people or the listed entity these days don't categorize certain person as KMP, and they are the senior management. It could be your departmental head or person who are very closely working with the management. So it's also important for the investor to know changes in those senior management folks. So that's why they have added this criteria. And there is a proposal to insert a new para. Uh, Earlier they introduced for the auditor, but now they have also introduced in case of resignation of KMP, senior management, and the director, other than independent director. If there is a resignation from such person, then you have to file the resignation along with the detailed reason within the 7 days of such resignation. Then the new proposal to insert the new para again, and this is very unique. So what is their intention is, like, suppose your managing director or the CEO of the your company, the listed one, is not available to fulfill the usual role which he is performing currently, then you have to disclose this event if such unavailability exceed the 1 month criteria. It is also important because these are the the brain of the company, and if they are not available for such a longer period of time, then definitely there would be an impact on the operation or the working of the company. And disclosure of such event necessary for investor to take the decision while investing or diluting its shareholding. Then there is a addition of time limit. So as you are aware, if you are like holding analyst or institutional investor meet, then as such there is no time limit prescribed to disclose this call or conference call to the stock exchange. Now they introduce the criteria, you have to like, if there is a, like, this is a proposal again, you have to disclose within the 2 working days in advance to the stock exchange about such meeting or presentation with the proposed investors or the analyst. Then again they have insert of proposal to insert the new para. uh, it most of the time your directors, promoter, or the KMP communicate with various media houses, which most of the cases are not, such information are not available with the investor. So now there is a disclosure so that investors are aware about such kind of communication with the media houses. And there are certain changes in the para B. And just for your information, para B of schedule 3 are those events which required disclosure if they meet the materiality threshold as per the policy. So the basic requirement is, in case there are the following events, if your company is entering into the arrangement for the strategic, technical, manufacturing type, such kind of arrangement, there is a usual disclosure. Now they have also added the word of subsidiary. So if your closure, there is a closure of operation of any unit, division, or existing provision of for the listed, but now they have added the word subsidiary as well. And the next change is quite important, because as of now, if you are entering into a loan agreement as a borrower, then there is a requirement to disclose this event. But in case of lender, if you are, suppose if you are lending to any of your group company or outside your group, then there is no requirement, because existing provision specifically mention that as a borrower, if the agreement is being executed. But now they propose to remove this word borrower. So now, if as a normal, if it is not, if it is lending is not your normal course of business, and you are providing the funding as a loan to your any of the group companies or outside, you have to disclose this event as well. And the last change is, there is one disclosure. They propose to add one disclosure in your corporate governance certificate. This is related to cybersecurity incident and cybersecurity breaches, and this is more relevant as well, considering uh, how the data privacy is important. So all those listed entity probably in future would find this disclosure in the corporate governance report, and they have to disclose. So these are the brief provision which SEBI has proposed to make necessary changes in the LODR. And I think apart most of the changes are good. It's more uh, about disclosing more event to the investors. But yes, that few of them require some sort of tweaking. Otherwise, that will create a problem for the listed entity. So I hope you like this presentation. Thank you.